Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and casual listeners who want to hear more about the latest trends and controversies in these fields. Each episode is presented by one of the specialty committees within the section. This episode is produced and co-hosted by the Global Private Litigation Committee of the Antitrust Law section. Today's episode is on trends in private litigation in the Asia Pacific. For our listeners most familiar with the American system, the U.S. has long had a three-pronged approach to enforcement of its antitrust laws. Federal enforcement by the Department of Justice and the Federal Trade Commission, state-level enforcement by state attorneys general, and by private litigants. Historically, private antitrust litigation has been less active in the Asia Pacific, or APAC, region, but that may be changing. While much of the antitrust news coming from Australia has focused on its adoption of a mandatory and suspensory regime for merger review commencing in January of 2026, Australia has seen a rise in private antitrust litigation on abuse of a dominant position claims under Section 46 of the Competition and Consumer Act. Parts of Asia are experiencing an uptick in private antitrust litigation as well. For example, in Japan, we're starting to see follow-on damages claims to enforcement actions against illegal cartels. What kinds of trends in private antitrust litigation are we seeing in this part of the world? What's causing them? And do we expect them to hold? Here to answer all of those questions with their unique insights are my guests, Kirsten Webb and Toshiaki Tada. Kirsten Webb is a partner and co-head of the international group at the law firm Clayton, based in Sydney, Australia. And Kirsten has deep experience in both competition and consumer law. Welcome, Kirsten.
Very pleased to be here, Anant.
I should say welcome back, Kirsten.
Thank you. Very pleased to be back.
And Toshiaki Tada is a partner in the Hibiya Sogo Law Office based in Tokyo, Japan. Welcome, Toshi.
Yes, thank you for inviting me. I'm very honored to participate in this meeting.
I want to start off by asking both of you, historically, how significant of a role has private litigation played in antitrust litigation in your country and why? Toshi, let's start with you.
Oh, okay. I have to say that the private litigation did not play significant role, especially 30 years ago, even in a follow-on damage claim. At that era, almost 100% of the enforcement was public, and namely enforcement made by JFTC, Japan Fair Trade Commission. One of the reasons was that the private litigation, plaintiff must prove the damage, of course, but the level of the proof was extremely high. They have to prove the exact amount of the damage made by, for example, cartel. But as you know, damage of the cartel is a difference between the actual price made by the cartelist and the price that have been imposed without the cartel. And the latter price without the cartel is basically a hypothetical number, and it's very difficult to calculate. And the judge wanted to have plaintiff to prove thoroughly. And in that sense, plaintiff have a very hard time. And actually, Japanese Supreme Court in the past 40 years ago, they dismissed the case because of the lack of the sufficient proof of the amount of the damage. And that really disincentivized the plaintiff side or the consumer side to file the lawsuit. That was one of the biggest reasons. And also, for the exclusionary conduct, the victim of the exclusionary conduct, they have to prove the damage too. And maybe the exclusionary conduct's damage may be more difficult to prove than the cartel. I have to point out this thing. And also, as for the situation on the standalone litigation, that will be even more difficult because plaintiff must prove the conduct at issue itself is illegal. And in that sense, plaintiff must prove that it was against competition order. And it's very difficult for private people to, even with a lawyer, what is a competition order and what was against the public interest. So basically, the high level of the burden of proof discouraged the plaintiff or the victim to file a lawsuit.
The damages issue is something that we see in multiple jurisdictions. And I think our listener, even though this is an antitrust podcast episode, I think our consumer protection professionals will relate to the issue of quantifying damages. Certainly in the U.S., for example, with data breaches, quantifying actual versus presumptive damages is a constant battle in that type of litigation here. But Kirsten, let's turn to you. What has been historically the role of private antitrust litigation in Australia?
Yeah, quite similar in many respects to the outline that Toshi's given for Japan in terms of follow-on litigation and the difficulties that I think are experienced around the world in quantifying damages, as you just said. And we have had on proceedings taken by private litigants. That has occurred over a long period of time, but there have been few and far between. There have been a few landmark private litigation antitrust cases that have gone up to our High Court. But when I say few and far between, I'm talking like 1989, 2003, big gaps between those cases. And I think probably like the position in Japan, from a private litigant perspective, the elements that you need to prove on liability in an antitrust case are complex. I think we haven't even seen enough enforcement litigation, antitrust litigation by our regulator in Australia, probably for the same reasons. A consumer protection litigation matter is more straightforward to run. It's quicker. It's not nearly as complex or expensive. And so over the longest time, I think we haven't seen sufficient antitrust litigation at all, and less private litigation, and certainly less follow-on actions than I think in the US. We have, though, had, as you mentioned, Anant, a quite significant, turning out to be significant change to our misuse of market power or abuse of dominance prohibition, which early signs are there that change perhaps has resulted in a higher number of private actions. We've only had one or two contested liability actions to date, but we're certainly seeing more private actions commenced and private misuse of market power potential claims as part of commercial strategies that are being developed.
For our listeners who may not be as familiar with that part of Australian law, can you give us a little background about that provision and what has changed?
Yeah, for sure. So we've had a prohibition, it's called a prohibition against misuse of market power. And before 2017, to establish a violation of that prohibition, you had to prove that a corporation had a substantial degree of market power in a market, and that the corporation had taken advantage of that substantial market power for a purpose of eliminating or substantially damaging a competitor, for a purpose of preventing a competitor from entering a market, or for the purposes of a person entering a market, or for the purposes of preventing a person from engaging in competitive activity. So you can hear, even as I go through the elements, that that's a complex number of elements that you need to prove. And one which was particularly challenging was, how do you prove someone has taken advantage of their substantial market power in engaging in conduct? The question was, do you ask, would they have engaged in the same conduct if they didn't have substantial market power? Or could they have engaged in the same conduct if they didn't have substantial market power? How do you take into account the business rationale or the commercial rationale for the conduct? And there were cases that went up to our top court, our High Court, to test those sorts of elements. In 2017, that provision was changed so that now what is prohibited is a person who has substantial power in a market will breach the misuse of market power prohibition if they engage in conduct which has the purpose or effect of substantially lessening competition in a market. So you just need to, so what you need to establish is that the person has substantial market power, that they engaged in conduct, which doesn't need to be in the market in which they have substantial market power, and that conduct had a purpose or has an effect or likely effect of substantially lessening competition. And it's generally considered that change has lowered the bar in terms of what you need to prove a misuse of market power. And there certainly has been an increase in private actions commenced or contemplated since that change has been made.
And I think that's one of the differences we've also seen between U.S. and European law. There's no comparable abuse of dominance standard in the US, but there is one in European law. And I think one of the ways they overcome some of the hurdles that you were describing is by building in a presumption. I don't remember whether statutorily defined or has been subsequently defined in cases that are brought, but trying to prove dominance in a market has often been a hurdle, certainly in other jurisdictions too. Toshi, what about in Japan? Are you seeing changes that are bringing about more private litigation?
Oh, yes, especially in the follow-on damage case. About 25 years ago or something, Japanese civil procedure law was amended, especially in terms of the damage proof. Now, once the plaintiff proved that there was certainly a damage, but the amount of the damage is very difficult to prove. In that situation, judge has a discretion to assume or admit what was the amount of the damage. So, of course, a judge is always conservative, so they would not give a high amount of the damage, but still, judge has a discretion. So those kind of new introduction of the law, it dramatically changed. But still, making a lawsuit is kind of very burdensome from the plaintiff side. And not so many cases are brought, but it has become changing. Yeah.
What's interesting is that the types of private litigation that the two of you are talking about are very different. One of them is follow on to your standard price fixing cartel. And Kirsten, what you're talking about is unilateral conduct, abusive dominance. Are you seeing in Australia some of the increase in follow on cartel litigation? Or Toshi, are you seeing in Japan an increase in the type of unilateral conduct that Kirsten was talking about? Are you seeing any kind of crossover from one jurisdiction to another?
Well, from my perspective, in the last few years, we haven't had that many cartel cases taken by the regulator. And so for there to be a follow-on claim, obviously there needs to be a successful cartel case run by the regulator from which the claim follows on. And we've had some cartel proceedings. The regulator hasn't had a great success rate in those proceedings. There are a couple that I think are currently before the courts. So probably wait and see a little bit in terms of the outcome of those regulated cartel proceedings and whether there will be a follow-on action after that. In Australia, we have a very long established class action bar, I suppose, and very active plaintiff firms. We have class actions on the consumer protection side. Frequently, we have class actions out beyond competition and consumer law. We have class actions, shareholder issues, whole range of issues. So it's not for a lack of a vigorous and enthusiastic class action bar. It may be simply that we haven't had very many cartel cases in the last little while.
As for Japan, perhaps like 20 years ago, especially in the public procurement area, there was many bid rigging, and the GFTC raised, and the municipality or the government, which made a public procurement, they vigorously pursue for the private litigation. But as I said, litigation itself is very burdensome. So Japanese government tried to guide the municipality or the public agency to have a special contract provision, which says if GFTC finds that bid rigging in our contract, you have to pay like 20% of the contracting fee. That kind of special provision was becoming very prevailing. And after that, basically the cartelist or the company which made a big rigging pay the damages based on that contract provision. So not so many lawsuits was filed after the introduction of those special contract agreement.
That's super interesting. We have a bit of a focus in Australia at the moment. Our regulator, the ACCC, has said one of its enforcement priorities is competition issues in public procurement, and I think it's working with our state governments to do data analysis and things to try to identify if there are any competition issues in the public procurement process. So maybe we'll see similar provisions appearing in our contract.
That is very. It seems very efficient for the government or the a purchaser. Yes, and also as for the not public procurement, but rather than the between the B2B transaction, Japanese companies always try to avoid a lawsuit. So in many cases, private negotiation is taking the lead to have the compensation. And as myself was involved in those kind of case, they try to have a settlement and avoid litigation because in the B2B area, they have a contract or transaction relationship and they want to have it, for the future too. So they can kind of make a compromise. And also at the same time, especially for the listed company, if the victim of the cartel did not pursue for the damage, the shareholder will make a file against the director of the victim company. So try to avoid the derivative action. The victim of the cartel listed company has an incentive to pursue for the damage, but still wants to avoid the litigation and then they make a settlement. That kind of situation is happening in Japan.
Are there limitations on the amount of damages that private litigants can receive that make private litigation in your respective countries either more or less attractive?
In Japan, only the single damage is permitted. And also in our law system, a very kind of a clear line is made between the sanction and the compensation for the damage. And the civil damage claim is only permitted to the compensation of the damage, and it cannot be a sanction. Sanction should be made by criminal or other administrative way. So we don't have a treble damage system, or we don't have a punitive damage system.
Yes, same in Australia. The regulator action, of course, the regulator has the power to seek penalties, very substantial penalties to be ordered against the contravener. And those penalties have achieve a whole range of objectives, including quite significantly deterrence. But in terms of damages, it's that there needs to be the link between the conduct and the damages, and the notion of sanction or punishment it is not relevant.
That's really interesting because in the U.S., the companies found guilty of participating in price-fixing cartels are subject to treble damages from the private litigation. The whole incentive for the Department of Justice's successful leniency program is that the first cartelist to come forward and reveal the plot is only subject to single damages. Like single damages is the reward you get for coming forward and blowing the whistle on the cartel. Let me turn now, as pretty much every antitrust panel in the last 5 years turns to, which is to big tech litigation. We have seen increasing actions, since 2020 and before by federal enforcers in the US and the EU, but we've also started to see globally more private litigation. Kirsten, I believe there was a major case by Epic Games. Can you tell us a little bit about whether you're seeing more private litigation in the tech space and what effect that's having on private litigation?
Yeah, well, yes, we had the Epic Games litigation against Apple and against Google. So for practitioners, super interesting. The court, same judge heard the case, Epic's case against Apple and Epic's case against Google, and 2 class actions all at the same time. So that was huge. And that the first instance judge's decision was handed down last year on liability, and both Apple and Google were found to have breached the Section 46 prohibition, not some other competition prohibitions, but in terms of the consequences of that, that's still being worked through the courts. In terms of other big tech litigation, that's the major private litigation of any kind, actually, in any industry in Australia. There has been an action that's been sitting there for ages, which was another private litigation action where an app developer commenced proceedings against one of the platforms for being excluded for various reasons. That I don't know what's happening with that. It's been sitting there for a long time. But the other litigation, the other big tech litigation that we've seen has focused primarily on the consumer protection side. There has been proceedings recently commenced against Microsoft by the regulator on the consumer protection side, and proceedings against Google concerning provisions in their contracts with our telecommunications companies, which were commenced but settled at the same time, if you like. So the proceedings were commenced by the regulator, but they'd negotiated a settlement package with Google. So that included that was a competition case, but not contested on liability or damages. So that's where we're at in Australia. But I think everybody's thinking, well, now we've had the first contested Section 46 case, and it has been a big tech case. We have seen quite a lot of other Section 46 cases being commenced in a range of industries. We've had the construction industry, where a Section 46 predatory pricing case was commenced and settled, and then a subsequent case with a similar structure has commenced. I'm not sure where that's up to in the courts. We had one in the pharmaceutical sector, which is unusual in Australia to have the big pharma companies litigating against each other. But that was a Section 46 case concerning some exclusionary conduct in a cancer patient program and interplay with the regulatory regime. That case was also settled. So you can see it's sort of part of a commercial strategy potentially in these disputes between corporate parties to use a Section 46 litigation strategy as part of their broader strategy. What about in Japan, Toshi?
Yes. As for Japan, almost no private litigation against big tech at the moment. And one of the reasons would be that GFTC made only one kind of official order against the big tech. Last year, GFTC made a cease and desist order against Google. But other than that, against Apple or Amazon or Google, they basically went to the commitment procedure. Commitment procedure is a kind of settlement between the GFTC and the big tech or the enterprise, which seems to made illegal conduct. And under the commitment system, the company promised to the GFTC that they would make remedies, but they would not admit that the conduct itself was illegal. And GFTC only declares that there was a suspect or the doubt that there was illegal conduct. So with that GFTC's decision of the commitment, plaintiff side will have a very hard time to prove that there was really illegal conduct. So they have to, produce additional evidences that the conduct that GFTC said only a doubt was not only a doubt, but really illegal. So maybe this will go to another topic, but under the Japanese civil procedure law, we do not have a discovery system. So it's very difficult for plaintiffs to obtain additional evidences.
That's interesting. We have full discovery and we have a procedure which is called preliminary discovery. And so you have the ability as a plaintiff to approach the court and ask for an order for preliminary discovery before you launch your proceedings on the basis that the respondent has information or documents that you need in order to assess whether you bring your claim effectively. And we're seeing some applications for preliminary discovery in misuse of market power cases.
Mm-hmm. That will be a very good tools for, especially in the exclusionary conduct area, because in a cartel case, of course, the victim may have the damage, but basically in the B2B area, the victim can pass on the damage to the other side. So the victim may not feel that they had a kind of damage, but in the exclusionary conduct, the victim always feel that they were very suffered from the conduct.
Yeah, and in Australia, exclusionary conduct cases arise if there's an effect on competition or if there's a purpose of substantially lessening competition, and internal documents as to what is being sought to be achieved by a particular strategy or whatever are very useful in working out whether there's a contravening purpose or not.
I'd like to ask you both about the impact of political changes on private litigation in your countries. Oftentimes, private litigation follows the fortunes of public enforcement because the public enforcers can either uncover some of these cases or they have the resources to do some of the initial discovery that private litigants don't. Certainly in the US, in the previous administration, there was active enforcement that also encouraged private litigation, but we've started to see something of a pullback in terms of public enforcement in other parts of the world, in the UK, in parts of Europe, where they're rethinking, or they're focusing more on maybe a strategy of growing their domestic companies as opposed to cracking down too much on them. through antitrust enforcement. I know there's recently been a change in leadership in the JFTC. I believe there was in the last few years a change in leadership at the ACCC. Have you noticed a change in political leadership at the tops of the enforcement agencies in your country impacting private litigation in your countries? Toshi, let's start with you.
Okay. I have to say maybe have a kind of a double standard, what we call. On their face, they say a private litigation is another way of, make a deterrence of the illegal conduct. But once that private litigation becomes very active, GFTC thinks that will be disincentivize cartelists to make a leniency. And also, if there is an active follow-on damage, company try to avoid the liability. And during the public investigation, the company do not admit that there was illegal conduct. That kind of resistance would be produced with the active private litigation. So I think JFTC, in their real mind, that too much active private litigation is not good for the public enforcement. So sometimes a court asks JFTC to produce evidences which they obtain during their public investigation. Of course, JFTC obey the order of the court, but they only produce a very small amount of the evidences.
Kirsten, what about in Australia?
Yeah. In Australia, we do have a new head of our ACCC. She's been in the role for a couple of years now. I don't think that the change in the head of the ACCC or, whatever might be happening politically has had resulted in any particular changes of the kind that you've described elsewhere in the world, Anant. I think our ACCC, like all agencies, hasn't got infinite resources, although sometimes it feels like they do. And they've been focusing, obviously, understandably, on getting ready for the mandatory and suspensory merger regime, as you mentioned at the start, Anant. But I think the ACCC continues to investigate antitrust violations. Investigations take a long time, and then they need to make a decision whether they're going to litigate or not. I think in the private actions that we've seen, parties, I think, are thinking, well, we can get this, prepare for this litigation, get it on, particularly if it's part of a commercial strategy with a settlement and with an objective of settling the litigation, can do that more quickly than the ACCC. I think the ACCC, in turn, sees that there are these private actions being taken, and particularly with the new Section 46, it has the ability to intervene, and I think it watches them closely. I don't think it's intervened yet in any of these proceedings, and for instance, the Epic Games proceeding being the first matter that has fully litigated the new Section 46. I have no doubt the ACCC was watching that very closely because there are matters of interpretation and how that section is going to be applied that are really important. But I think we of course, have had, as listeners probably know, a digital platforms inquiry led by the ACCC for a very long time now, a rolling inquiry, which it has been directed to undertake by our Commonwealth government. With those kind of inquiries or market studies, I suppose, almost inevitably, conduct is uncovered, which down the track might result in regulator proceedings, and that has been occurring. And I suppose reports from a regulator in a sector like the digital platform sector, identifying conduct that might contravene our competition laws, does give some basis for private sectors, for the private litigants to say, or commercial parties to say, well, hang on, you're engaging in conduct that the ACCC has said in that report is illegal, and use that as a negotiating strategy. So we're certainly seeing those sort of things, but I don't think we've had a change. I haven't seen a change of the kind that we hear about in the US and in the UK. And then,
Kirsten, that multiplier effect that you were talking about, I've started observing that more recently in the US, where the Department of Justice, even with its, limited resources in terms of just how much funding and how many attorneys it has, I have started seeing a more robust policy engagement strategy where even when the United States government is not bringing the case, they will file a statement of interest in a case to make the position of the U.S., its interpretation of antitrust law known without necessarily having to commit all the resources to bring their own separate case, which I think has had a positive impact on some of the private litigants.
Yeah. And I think, in the Epic Games against Apple and Google, that was a huge piece of litigation. And obviously all of those parties were very well resourced and very well represented with the top antitrust law firms and counsel. And so I expect the ACCC watched that closely, but there was no need for it to intervene, but it could, as you say, doesn't then have to incur the costs of running the litigation itself.
And Toshi, your story about a reluctance on the part of the enforcement agency to encourage too much follow-on private litigation, I had not heard that story before, but it resonates wholeheartedly with something that I experienced. So part of my background, I was a staffer on Capitol Hill, and when ACPERA, which is our federal whistleblower leniency law and antitrust, was due for reauthorization, we heard from DOJ, which under its leadership at the time wanted the statute to be reauthorized as it was. And then we also heard from the private bar, which felt that in the private litigation, the leniency, the cartelists that had received leniency oftentimes were not sufficiently cooperative with follow-on private litigants, and they wanted a stronger requirements under the leniency law to support private litigation, which neither the DOJ nor the defense bar was in support of. So you saw that same tension, and I had not heard of it anywhere else, but it's interesting that you've seen the same thing in Japan.
I believe I didn't hear any official comment from the JFTC staffs, but in a very unofficial side, when we make a leniency and talk about the private litigation, the leniency officer says sometimes that kind of things, and also, but still in the U.S., as you said, the lenient applicant can get the reward of the single damage claim. So that may be a strong tremble damage class action system will incentivize the cartels to make a leniency application. But in Japan, as I said, only the single damages are awarded. So maybe that is one of the difference between the US and the Japan. But especially after the auto part international cartel cases, Japanese corporation realized that leniencies only can reduce the amount of the administrative surcharge or the criminal fine, and they were exposed to the private litigation all over the world. So, and that kind of experiences now affects the Japanese corporation. That's my assumption, but because of that, Japanese corporation now is very become a conservative to make a leniency application, considering the exposed to the private litigation.
Both given us a really clear picture of what the state of private antitrust litigation is currently. What are your predictions for what we should expect going forward? Kirsten, let's start with you.
I think we will see more private litigation in Australia alleging breaches of the new Section 46, and particularly if there's conduct that might be in a single product market, which was the case, which is what the court found in the Epic Games litigation. And I say that because if it's a single product market, the ability to prove substantial market power is almost self-evident. And with this new provision, which says you have to prove substantial market power, you have to prove conduct, and you have to prove a purpose or effect of substantially lessening competition. If you have substantial market power in a single product market, based on the first instance decision in the Epic Games, all of the Epic Games litigation, there's a real question about if you even need a connection between the market power and the conduct that substantially lessened competition. And so to the extent, and we'll see, I'm sure it'll be on appeal and that law will be clarified, but it might be, and for these litigation matters that are litigated around the world, it might be that Australia is seen as an easier place to prove a misuse of market power. And so rather than Australian proceedings coming at the tail end of global litigation that might come further up, which is something for our listeners to think about, because there is certainly a view that as a consequence of the court's decision in the Epic Games litigation, if you have substantial market power in a single product market, it probably is easier to prove the effect of that conduct on competition. The judge kind of didn't dismiss the notion, the rule of reason kind of notion, as something to be considered in analysis under Australian law. So I do think for our listeners who might act for or might be global entities, perhaps the risk of antitrust litigation in Australia goes up a bit higher with what we're seeing as a consequence of the Epic Games litigation. That's my take anyway.
For sure. If you do global competition strategy for a company, that would really invert things. Very interesting. Toshi, what about Japan? What are your predictions?
Yes. I haven't touched upon the conduct of the abuse of superior bargaining position. This is an exploitive conduct, and it is not an exclusionary conduct, or it's not cartel, a very unique type, especially in Japan or maybe in Korea or in other countries, but a very unique type. And this abuse of superior bargaining position is, I won't go into the detail of the substantive law this time, but if there is a kind of transaction terms lacking the economic rationality, and that will harm the counterpart of the contract, then there will be a abuse of superior bargaining position. And that kind of conduct is easier for the plaintiff side or victim to prove that there was a harm and illegal conduct. And actually, there is a Tabelog case. It is now in the Supreme Court. And the Tabelog is a huge food restaurant review website. And the Tabelog basically collects all the information from the consumer about the restaurant all over Japan. And they estimate and then rank, and this restaurant is a star with a 4-star or 3-star, that kind of thing they do. But once they change the algorithm of the estimation, and after the change of the algorithm, one of the chain restaurant store estimation was became very low, and because of that, they not so many customers came to the restaurant, so they filed a lawsuit on the reason of the abuse of superior bargaining position, and that kind of things are happening, and the Supreme Court will decide how they interpret that that conduct. So after those Supreme Court decision will be made, I think there will be more private litigation in terms of the abuse of superior bargaining position.
Well, we'd like to end these episodes with a few key takeaways for practitioners. So, Kirsten, let me start with you. What are some key takeaways here?
Key takeaways for practitioners who aren't so familiar with Australia. One, we do have a long-established class action bar. We're seeing more antitrust private litigation and hopefully regulatory litigation. The legal test has changed and is likely to be easier to establish. And so in terms of considering litigation risk in Australia, I do think that the litigation risk in Australia for antitrust litigation is higher than it was, say, 10 years ago.
Yes. For the plaintiff side, as I said, the civil procedure amended, but still the lawyer must have strong intention to pursue many. And so plaintiff side still may have a hard time, but the situation is changing. But from the defendant side, as I said, Japanese corporation try to avoid lawsuit. So I think advice for the defendant side will be how to make a good negotiation or to make a good settlement with the plaintiff side will be the very key concern from the defendant side.
Well, this has been a great discussion. I think for anyone involved in global competition litigation or litigation strategy, there are a lot of good pieces of information here about what to expect from a part of the world that they may not have a lot of experience litigating in. So Toshiaki, Tada, Kirsten Webb, thank you so much for lending your expertise to us. And for our listeners, be sure to subscribe on your podcast platform of choice. And we'll see you next time on Trust and Trade.